Welcome back to another Law Talk with AB, where we dive deep into legal theories and stories that are shaping our country and our news circuit today. No spin, just the facts, and a little analysis to keep you ahead of the curve. I'm Aaron Border. Right now, the Trump administration's aggressive push on executive power is hitting wall after wall in the courts. And frankly, I would argue that's exactly how the system is designed to work. One branch tests its limits. Today, we're breaking down three massive unfolding battles that are testing the Constitution in real time. The high-stakes Supreme Court case of birthright citizenship is heading to oral arguments in just weeks. The brand new lawsuit slamming the administration's post-Supreme Court tariff switch. And finally, the wave of federal court interventions blocking and or limiting immigration enforcement moves. These aren't abstract debates. They're real-time examples of separation of powers in action. The executive acts boldly, Congress's delegate authority gets scrutinized, and courts step in to enforce their constitutional and statutory lines. Stick with me as we unpack how all of this plays out right now in real time and why it matters to everyday Americans like you and I. Let's jump right in on what can be to some an extremely controversial topic, the birthright citizenship battle. The Supreme Court is set to decide a core constitutional guarantee where real shortly President Trump is going to face a big battle in the courts. Let me just tell you how it all shaped up. President Trump kicked off his first day in office of the second term on January 20th last year with the Executive Order 14160, aiming to end automatic birthright citizenship for children born in the U.S. to parents who aren't citizens or lawful permanent residents. The order interprets the 14th Amendment as, quote, subject to the jurisdiction thereof extremely narrowly. It's excluding children of undocumented or temporary status parents of children born after February 19th, 2025. This directly challenges over 125 years of settled law, starting with the landmark 1898 Supreme Court case United States v. Wong Kim Ark, which confirmed that citizenship by birth on U.S. soil for children of foreign parents. Now, once this executive order was signed, the lower courts moved fast. Multiple federal judges issued blocks calling the order blatantly unconstitutional and a threat to the bedrock protections, and the administration, of course, appealed. And now it's in front of the Supreme Court, and it is under the case Trump v. Barbara. Oral arguments are locked in for April 1st of 2026. Briefs are flying in with the government pushing originalist arguments tied to post-Civil War history and limited jurisdiction for non-allegiant aliens. Opponents hammer the plain text, centuries of practice, and the fact that changing citizenship rules require a constitutional amendment, not executive orders through fiat. This could redefine who counts as an American citizen in the modern era. Supporters say it's closing loopholes that fueled chain migration, and some say anchor babies and had a magnet for illegals to come over, and it strained our resources. Critics warn it's an unprecedented overreach that undermines the 14th Amendment's promise. Either way, we'll be watching this one very closely and bringing you play by play. It's really a direct test of how far presidential authority can stretch before the judiciary says, nope, you've gone too far. You know, some of President Trump's supporters, they believe that the Trump administration knew all along that this would end up in the Supreme Court with the executive order being tested. But they felt like this is what they had to do to get the legal ball rolling. I guess that's a perspective too. So we will definitely follow on and let you know how this all plays out as it unrolls. Now let's shift to the president's favorite word, tariffs, and see executive power pivot under fire. In our last episode, we covered that on February 20th, the Supreme Court ruled 6-3 that the International Emergency Economic Powers Act, IEEPA, doesn't let the president slap broad tariffs unilaterally on our trading partners. They struck down the prior measure and opened up refund doors for our importers. The administration didn't back down. True to form, just days later, on February 24th, new temporary tariffs rolled out under Section 122 of the 1974 Trade Act, Up to 15% can be placed on our trading partners, but most were around 10% tariffs. And they were only to last up to 150 days. This was framed to address the balance of payment that has created a crisis by the prior ruling. Of course, on March 5th, as predicted, possibly anticipated, a coalition of 24 states, half of our country, sent their attorney generals, mostly Democrat-led attorney generals, including heavyweights like California AG, the New York AG, Oregon. They filed suit in the Court of International Trade. They argued Section 122 is being stretched way beyond its narrow emergency intentions, and that it most certainly was not designed to cover chronic trade deficit. And again, they argue that this is a bypass of Congress's core taxing power under Article 1. So, more importer challenges are piling on with new tariff action. This is textbook separation of power tension. Presidents get to use tools of trade emergency, but courts get to decide when statuses are being pushed too far. The economic ripple effects are huge. Many industries are feeling higher costs to do business as this all plays out. Ongoing refunds from the old tariffs and uncertainty are rippling through the supply chains. It's the system checking aggressive executive moves in real time. The markets want stability, and they'll adjust accordingly once that happens. The US is the world's largest consumer of goods, so it'll all balance out. However, the ongoing litigation in the Supreme Court is leaving massive uncertainty in the markets, and that's transferring to our wallets. So we'll keep you all abreast of this case, as we'll be following it very closely to see where it goes and how the administration responds to rulings. Well, folks, President Trump promised on the campaign trail for massive deportations, so it's no secret that it's happening. Now, he's the president and he controls the executive branch, which controls ICE and DHS. These two agencies lead immigration enforcement, but federal courts are actively reviewing every major step for compliance with statutes and the Constitution. Right now, we are seeing fresh blocks. A federal judge just ordered ICE to fix inhumane conditions in Baltimore holding cells, certifying a class action for anyone detained there. And in DC, another court partially halted sweeping changes of the Board of Immigration Appeals and their rules that would have slashed appeal deadlines and gutted meaningful reviews, ruling that changes would violate notice and comment requirements. Lower courts continue scrutinizing detention for due process violations, while the Supreme Court has already reaffirmed deference to agencies on asylum facts, but only when actions stay within legal bounds. Well, that's a broad scope, right? This dynamic is built into our system. Courts defer to executive expertise on the day-to-day enforcement, but enforces hard limits on overreach. This divide is intense. Supporters call this action judicial intervention by activist judges that are setting roadblocks to sovereignty and security and blocking presidential power. Critics, however, see them as vital safeguards against excess from presidential overreach. It's fueling massive polarization, while this viral clip from the past weekend shows tense confrontations during enforcement action. Wow. This is truly a polarizing time. These are big, important cases that will alter the landscape for years to come. As we step back and look at these three cases just today, birthright citizenship, tariff challenges exploding in the court, immigration blocks rolling in by federal judges, bound to go to Supreme Court on appeal, of course. These are live demonstrations of how America handles executive ambition. Bold moves to get met with judicial review, statutory limits, and congressional checks, just as the founders engineered. What a fascinating time to be alive. What are your thoughts? Do these cases reinforce essential limits on power, or do they tie the executive hands when decisive action is needed on trade, immigration, and citizenship? How do you see the separations of power playing out in these real-time cases? I'm curious to hear from you. If you're getting great value from Law Talk with AB, let me know. I want to give you straight facts, deep analysis, and insight on how the system actually works. If you're loving it, smash that like button, drop us your take in the comments, and subscribe and share with your friends. Until next time, stay sharp, stay curious, and I'll catch you in the next episode. This is AB, I'm out.